We're ready for Mr. Wolfenbarger, please. That's not mine. Break. We had agreed that we would come back a little bit early to discuss what we expect will be the afternoon testimony of the domestic violence expert.
That's correct, Your Honor. I assume she's the next witness, is that right? Or no?
Maybe, no. It'll be Hawk. Hawkdale, I believe. It might be the next witness.
Is Hoptel the medical examiner?
No, Hawkdale is the
Anthropologist? Yes.
dentist,
she's
the
the
forensic dentist.
Okay, but presumably that will be relatively quick?
It is quick, Judge, but just so the court's aware, it is quick, but the defense agreed to allow us to present her via Zoom. There were some issues with her travel. Okay. So I'm going to send her the Zoom link now. Okay. And then we just need to let the court know to let her on when she's ready to go.
Sure.
James will be today.
That's what we expect.
We believe so, yes.
I'll assume we are making good use of our time then.
Okay.
We talked about this last Monday, I think, in our pretrial motions hearing. The issue is whether Dr. James, Dr. Rosa James, kind of what the scope of her testimony is going to be. She doesn't know any of the facts of this case. I think we all agree with that. She hasn't seen any police reports. She hasn't interviewed any witnesses. You know, she is, I've heard different phrases used, but a witness who has no knowledge of the facts and instead is simply going to educate the jury about, I don't know what, but in general, the behavior of perpetrators and victims of domestic violence. It is my fear that is going to involve hypothetical questions, which will, in effect, serve to educate her about the facts of this case, many of which will be contested, probably, and that it will be, under 403, an improper way of introducing expert testimony. But more importantly, even if it is limited to hypothetical questions, and I don't understand, let me just get to the point, what the bottom line is. What is the final conclusion that the expert's going to say? If she's going to say, it is not uncommon for people to ask for TPOs and then withdraw them. And here's how the cycle of violence, often works. I'm not saying it's true in this case, but this is in fact a phenomenon known to doctors, sociologists, psychologists, whatever. First of all, we've already had the testimony. We just had that from the detective who said, oh, it's not uncommon at all for people to withdraw their TPOs. But fine, if they want to do that one more time, I'm less concerned. I'm not going to say I'm not concerned, but I'm less concerned. What really concerns me is what we got a taste of last Monday when she started talking about the threat of leaving increases the lethality rate by whatever the percentage was. And even more importantly, any suggestion that there is a history of abuse here other than what's in evidence is completely inappropriate. Right? I mean, we can't be having this witness either answering hypothetical questions or talking about the cycle of violence. I mean, if you just look at her chart, it's over and over and over again. You get beaten up, you complain, then you make love. Then you get beaten up again, and you make love, and you complain. There's no evidence of that in this case. And I can't understand why the prosecution should be allowed to put up an expert to pretend it is the evidence in this case. and then to get an opinion. This is common in the field. You know, my basic argument is that under 404B, that's essentially propensity evidence anyways. You're essentially saying he did it in the past, and therefore he's guilty of this case. And as we talked about last week, you know, the law on this subject has become crystal clear that the prosecution has to be specific and precise about the reason that the evidence is being offered of prior acts of violence. If it's a self-defense case, it can be offered to prove it's unlikely self-defense because he used the same defense last time. If it's a lack of knowledge case, it wouldn't really be applicable here. If it is a...
Sir, sorry, sir, if you could step outside. Thank you, that's okay. That was the record will reflect that was the witness who's on the stand. I've asked him to step outside.
That's fine. You know, or even lack of intent. None of those are issues in it. This is a whodunit. This is strictly who committed the crime. And even if they have, you know, by preponderance of the evidence or something that would satisfy, you know, the court that it's at least admissible evidence that there were some prior episodes of, you know. Oh, no, that's okay.
We just didn't know where the noise was coming from. We're all like...
Go
ahead.
I lost track, of course, but and that was intentional on the DA's part.
Sure, he's absolutely messing with you.
The point is, in a case in which the defendant denies doing it at all, the threshold for similarity and for the admissibility of 404B evidence is far higher. As I said the other day, it has to literally be the mark of zero. You can't say that he denied doing it, but by golly, we're going to prove it wasn't self-defense. Nobody's ever said it was self-defense. They can't, you know, they can't say, you know, he denies doing it, but by golly, we're going to prove whatever he did with intent. Or, you know, course of conduct, which isn't even an accepted one under the Georgia rules anymore. So they just need to be precise now, ahead of time, instead of making me jump up and down like, with the jury.
What is that?
Your Honor, I apologize. In preparation to get ready, we were setting up the Bluetooth, but we're done.
Okay, thank you.
I think you understand my point. If you're going to use it for identity, you have to show only this person could have perpetrated the crime because of his MO. This is the way he operates. He kills people, and then he dismembers them. If they have prior incidents of that, then they can certainly put in evidence of prior dismemberments he's committed in order to prove that he is the most likely candidate for being the perpetrator in this case. But other than that, the fact that he allegedly, and I stress that because I don't even know where the evidence is going to come from at this point, that he allegedly scratched her arm, dragged her down the sidewalk on one occasion, and I mean, there's been inconsistent evidence of there's no other arrests, no other contact with police, no hospitalizations, no doctor's reports, no pictures. There's nothing else other than the one TPO in July of 1998. So I think the DA should be obligated to preview what she plans to do and make sure that it's acceptable to the court.
Okay, thank you, Mr. Samuel. Ms. Hilton.
Yes, Your Honor. Thank you, Your Honor. As we discussed last Monday with the testimony of Ms. James, we advised the court that we would be bringing Ms. James up towards the conclusion of the case, or not the conclusion, but towards the end of the case after we believe evidence of violence would be admitted. At this time, Your Honor, the court has not just heard about a July 1998 incident, but the court has heard through the witness Tina Mae Patton about an instance in which she saw her sister come to their job at the Waffle House, that she saw bruises on her sister's neck, that when she asked her sister, either one remembrance is either her sister said it was Chris, or when she asked it was Chris, her sister kind of indicated in some way to confirm that that's who perpetrated that injury on her. We also know that there was a secondary time in which Tina Mae wanted to confront Chris about the abuse he was perpetrating on her sister, and her sister asked her not to approach him in fear of what that may do to him. We also know that there is testimony, and this is the state's position, that this defendant moved her to a community in which she had no familiarity, did not know anyone, which we believe would be a form of isolation. That when they moved to that community, she never spoke to any family, she never spoke to any neighbors, she never spoke to anyone there, so she was pretty much just in the house. I believe Miss Dorothy Jones, or Dorothy Cooley, testified herself that she didn't even know her name, never spoke to her, even though Mr. Wolfenbarger had a relationship or a friendship of such with Miss Cooley, and we believe that is evidence of isolation. We know
the evidence of her not being there,
and I think that's an argument that they can have. Additionally, we have evidence that Miss Dorothy Cooley heard arguments in their home, that even though she tried to change her testimony on the stand, what she said at one point in time in her testimony is that she would hear her screaming. She also noticed or saw Miss Wolfenbarger with a black eye under her eye. She was wearing glasses, but she did see markings of black eye. So there is evidence of physical abuse. We know that she also told her mother about the 1998 incident, about the dragging of her. So we know that there is indications of physical abuse. We believe that that information in and of itself shows that there was a pattern of abuse such that Ms. Rosa James could testify as to the domestic violence dynamics. What are certain signs in that pattern and control? And the jury can make a decision whether or not they believe that this is a domestic violence relationship. It is the state's position that this was a domestic violence relationship. We believe that there's evidence to present, whether that is in hypotheticals, to Ms. James about some of the events that occurred in Ms. Wolfenbarger's life leading up to her death. We do believe that she'll be able to testify as an expert in domestic violence that the most dangerous time for a woman is when she attempts to leave that relationship. I believe that there is evidence that Mr. Wolfenbarger, in his own words, will say that in December of 1998 that the two of them were trying to work it out, but I believe her mother testified that she wanted to leave him. I think that testimony came in, I believe so. So there is evidence that she did want to leave him, and such that we think that there is enough information to make Miss James's testimony relevant before this jury, and it is not excluded by Rule 403, that it is more probative, and that the prejudicial effect is not substantially outweighed in this potential case. And so that is the state's intention at this time. We do believe that, again, that there is evidence. Whether or not the defense counsel, crosses her on it and talks about isolated incidents and things of that nature, I think they very well can. But we believe that there's enough at this juncture, Your Honor. And that would be the state's intention. I think we discussed last Monday, the state would never ask the ultimate conclusion. Based on all this, did he kill his wife? That would never be a question that the state would ask. But we definitely intend to ask questions about statistics, regarding the most lethal time for a victim in an abusive relationship. And so that's the state's position, Your Honor.
Thank you, Ms. Hilton.
I would point out, we have not been given any statistics. We've not been given any evidence.
We asked for it a week ago. Sorry.
I mean, if she's going to start talking about 85% of all people who want to leave their family get murdered.
I didn't hear Ms. Hilton say that. What I heard Ms. Hilton say was the very broad, generic statement that I've heard from, I think, every DV expert ever, which is that the most dangerous time, that there are particular times in a domestic violence cycle that are particularly dangerous, one of them being when someone has attempted to leave.
Wow.
I'm not saying that I'm saying it's admissible right now. I'm just saying I didn't hear her talk about statistics.
She used the word statistics. I didn't make it up. She said that she's going to cite statistics. So I don't know if that meant, you know, in general it's the most common time, or if she's actually going to testify to 87% or whatever.
The general research, I should say, maybe not statistics, but the general research that the most dangerous time for a victim in an abusive relationship is when they're trying to leave.
Okay.
It sounds like, you know, almost kind of like profile evidence, you know, and it's not the way someone gets convicted of being the perpetrator. It may be a good, as one lawyer described it recently, a good sword for proving, you know, this is the perpetrator. If this is, it was intentional as opposed to accidental, or a way to defeat a claim of self-defense. Say, you know, you've beaten her up 30 times, and you're claiming this is self-defense this time, you know, or it was, you know, suicide. You know, you were trying to take the gun away from her. But he's saying he had nothing to do with it. He had nothing to do with the crime. And yet they're going to use this profile evidence of what other people, you know, based on some similarity, I guess. I mean, I know what she's going to do because she did it the other day with me. You go through the wheel and you say, oh, you know, you don't have to have all these things. You have to have a couple or a few or some number of them. And, you know, we get into this argument where everybody's a domestic abuser, you know, under her theory. If you take the wheel out, wherever I did with it, you know, and start going through it, everybody satisfies. You can go through it and say, there was no evidence of this, no evidence of this, no evidence of this, no evidence of that. She says, it doesn't matter.
And that goes to the weight and credibility that a finder of fact should afford to her testimony,
It is
assuming that
unfair.
she's allowed to testify.
It is unfair. It is 403. It is the jury's going to hear she's the most qualified person on the planet to be offering these opinions, and you know we're apparently nitpicking over, you know, things that she has studied and the statistics and all that.
Understood, Mr. Samuel. So what I heard from the state is the identification of at least, I think, three instances from which either there is actual testimony of an event like the matter in July that I think led to the TPO, or there are facts from which a reasonable inference for purposes of a preponderance might be drawn that there was some abuse. And so as a result of that, I do believe that the state has made, there are facts that they can ask the expert about. I do want to put one issue to bed, and Mr. Samuel and I discussed it at the pretrial conference last Monday as well, and that is that 404B has been thrown around a little bit, and I think I understand your argument currently to be that it's 403 prejudicial, but the argument that you're making, I still stand by that it is intrinsic to the nature of this relationship, and that is what distinguishes it from this sort of argument that might not fly, that, you know, if Mr. Wolfenbarger, if there was evidence that Mr. Wolfenbarger had abused someone else before, that would exponentially increase the likelihood that he had abused Melissa Wolfenbarger. That's not what we have here. I'm specifically looking at Hughes versus State, which is a 2021 decision of the Supreme Court, talks about similar evidence in terms of an incident where the defendant was alleged to have slashed the tires of the victim, and the defendant ultimately argued that that was inadmissible 404, that it was prejudicial, and that it was error to allow it in, and Justice Boggs said it was both intrinsic and evidence of prior difficulties. And so I think it's relevant, I think it's admissible, and under 403, I don't believe that it is overly prejudicial. Now, having said that, I think we talked about this on Monday as well. The state is, I don't think that the state intends to go out on that limb, right, and ask the witness questions like, you know, the ultimate issue and other things. But I did hear a concerning willingness by that victim to walk out onto that ledge all by herself. And so I just want to make sure that you have cautioned your witness to understand the parameters of what's allowable for her to testify to.
I have, but I will again prior to her testimony when she gets into the building.
Understood. The remainder, Mr. Samuel, as I said, your other concerns about the scope of her testimony, the veracity, reliability, et cetera, I think goes to, again, the weight and credibility to be given to her testimony. And so that's going to be my ruling regarding the ability of that witness to testify and to base hypothetical questions on facts that are actually in evidence regarding 2 to 3 either specific instances or facts from which a jury could infer, a fact finder could infer an abuse.
Can I just ask,
Instance.
let's assume you ask the hypothetical questions. Assume 3 incidents and describe them with specificity and accuracy. What is your conclusion? What are we inviting her to conclude? You are dealing with an abuser. And once we've made that finding, Katie bar to the door. At that point, we can do anything we want to do once we've identified him as an abuser. That's what I'm trying to figure out. Let's assume he did it 3 times. What is she going to conclude? Is it anything you could do? It wouldn't make a difference if it was 3 or 30. At that point, everything I want to offer as an expert, I can offer.
Ms. Hilton? So I think my understanding and Mr. Samuel's understanding clearly is that this expert would be offered to testify about what an abusive relationship looks like and how people behave in that relationship. Is that fair?
Yes.
To educate the jury about those issues.
Yes.
Beyond that, Mr. Samuel's question about what actual opinions or conclusions do you expect that this expert will draw regarding this case? Or is she just educating the jury generally about what an abuse relationship looks like?
Generally as to what an abuse relationship looks like, and if there are certain hypothetical facts be consistent with coercion or power and control. So
hypothetical facts for which there's a reasonable factual basis in the trial.
Yes.
Okay.
Yes. And so that is the extent, but she's not coming, we're not asking her any, is this domestic violence? It's more if a person brings someone to a neighborhood and they don't have any family there, could that be considered isolation? So things of that nature, factors that one could maybe conclude at some point in time or that we'll be able to discuss, but that's the state's intention, Your Honor.
Mr. Samuel, I understand and imagine that you would not be satisfied with that response.
Well, a few minutes ago is the first time I ever heard there's some theory that part of the whole, maybe as you're describing, intrinsic conduct was moving to Atlanta, to get away from her family, which is what, the other evidence was. But now we're going to have this witness say, oh, if you've moved to Atlanta, to a home that their family owns, right?
Right.
I mean, they own this apartment complex, the duplex.
Which are all facts that you can cross-examine the witness about.
But that's the whole point, is she doesn't know any facts. So I got to take her hypotheticals and say, let me pull a few threads on these hypotheticals. How about if you found out that the home to which she moved, was actually a home owned by the family? And she says, no, it doesn't make any difference.
I understand. My ruling still stands, Mr. Samuel. I'm going to let the witness testify. I think that your concerns relate to the weight and credibility that a fact finder should afford to her testimony, beyond the fact that, as I've said a couple of times now on the record, and Ms. Hilton has assured me, is that, we're going to make sure that our hypothetical questions are tied to the facts in this record even if they're conflicted facts. As long as they've been established by somebody in this case, number one, and number two, that we're going to make sure that this witness is not expounding in a way that would be problematic in terms of the ultimate issue or offering opinions that there are no facts to back up, even if they're conflicted facts. Okay?
Yes.
Okay, that's my ruling, Mr. Samuel. Anything else that we need to take up before we have the jury back in to conclude the detective's testimony?
No.
Okay. Ms. Hilton, you ready?
I think Mr.
I'm sorry, Mr. Fawcett, are you ready? No, I understand. I just was making sure both sides are ready. Deputy, can you get our witness back, please? And then we're ready for the jury. Thank you all. Please be seated. Detective, I'll just remind you that before we took our lunch break, you were sworn in and that you continue to be under oath, okay?
Yes, ma'am.
Thank you. Mr. Samuel, questions for this witness?
Detective Shepard, my name is Don Samuel. I don't believe we've ever met before.
I've met you in passing before.
This is the second one to say that. You joined the cold case squad in 2020, did I get that right?
Approximately, yes.
Okay. And when did you pick up Calhoun's reports and start looking at this case?
2021.
Okay. So in 2021, we are essentially 23 years after for example, the first thing you testified about, I think, was the July TPO, right?
Correct.
Okay. Obviously, you weren't there then. You didn't have, contemporaneous evidence of what happened on that day, right? You didn't interview any of the witnesses.
That's correct.
That led to the TPO, correct?
Correct.
And when I say TPO, I'm talking about a temporary protective order.
That's correct.
And you introduced some exhibits this morning. Yes, this morning, dealing with that TPO, right?
Yes, that's correct.
Okay. So what you learned from reading Calhoun's reports and what led you to think the TPO was important was that there was an argument, correct? There was a dispute?
Yes, there was a physical dispute that resulted in Melissa Wolfenbarger's injuries.
It resulted in?
Her injuries?
Okay. Did you interview someone named Perone who was involved in that?
No, I never got a chance to interview Ms. Perone.
Okay. And did you talk to the law enforcement officer who went to the scene, whose name is Sutton, I believe?
No, every officer during that time, by the time I received the case, pretty much retired. But I was referring to his actual police reports that were documented.
Well, he came here. It wasn't that hard to find him. He came here and testified. Did you ever talk to him?
No, sir, I never was able to talk to the officer.
Were you aware that he said he never saw any bruises on her back?
The only thing I had to refer to is it wasn't the actual police report that he documented when the incident occurred.
Right. Well, he didn't document what he saw. And when he testified, he said, I didn't lift up her shirt or look at anything on her back. I didn't see any. In fact, he said she had some bruises on her legs.
To counsel testifying.
I'm cross-examining him.
Yeah, I'm going to overrule the objection.
I have no direct knowledge to his testimony when he testified in here.
So if, in fact, his testimony is different than what you said this morning, obviously you don't question his credibility when he came here and testified under oath.
I think Officer Sutton will have to be the one to speak on that. As far as his credibility, I can refer to the documents that were documented in the official police report.
Okay. And do you know from the official police report whether the officer or anybody interviewed Mr. Wolfenbarger that night?
Not sure. I don't have any reports that stating that either.
Or Mr. Perone that night?
There are no police reports that's documenting that.
Okay. So you have Sutton's police report, which is inconsistent with the testimony he gave to the jury, and that's it as far as what led to the temporary protective order.
Again, I can't testify to Officer Sutton's testimony that he testified in here. Only thing I have to go by is what he documented in his police report.
Okay. All right. Now, as a result of whatever happened that day in July something like 22nd, right, 1998, Ms. Wolfenbarger was encouraged to take out a TPO, correct?
Yes, after she was assaulted and dragged by Christopher Wolfenbarger and received the injuries. Usually when there's a domestic dispute, we always refer to the victim in that domestic. That's an option that they can go and seek as a temporary protective order for further protection.
Can I ask you to do me a favor?
Yes,
when
sir.
I ask you a question, you can answer yes or no. Okay?
Cool. Okay.
All right?
Yes, sir.
If you think it's a deceptive answer and you need to explain it, that's fine. But, you don't know what happened that night. You just know what's in the police report, right?
Correct. The only thing I know is what's documented in the police report.
Okay. By the way, did you even try to find Officer Sutton?
I have the official police reports that I can refer to, and that's usually what happens. A lot of cold cases, we don't reach out to those the officers that officially responded to the first scene. We go by the police reports.
Okay. So at any rate, it was customary to refer Ms. Wolfenbarger to get a TPO, correct? A temporary protective order.
Yes, sir. Anytime there's a domestic dispute and the victim of that domestic dispute.
Sir, I just asked you a yes/no question. She was referred to get a TPO, correct?
Yes, she was correct.
You want to make a speech every time I ask you a question, or just say yes or no if you can, all right?
Are you asking me, sir?
Not really. So she takes out a TPO on what day?
We have to refer to the actual document again if we want to get the exact date. Thank you.
Some of those are not in evidence in full, you may remember, but do you have the date that the TPO was taken out?
As soon as I find a TPO, I can give you the exact date. It looks like it was July 2nd, 1998. July 22nd, I'm sorry.
22nd, okay.
Correct.
And then what a TPO does is, that's just ask the court to set down a hearing, correct?
But TPO is, again, another form of documentation along with the police report where they document through the court that this person that's filing the TPO needs protection from the person that they're trying to get protection from.
Right. But it has to be followed very quickly by a court hearing, correct?
Well, that depends on the court.
Okay.
But once it's filed and it's enacted, the person, we have a court hearing, they're served, and at that point they're served with that temporary protective order. They have strict orders not to violate that temporary protective order.
How long did the TPO in this case exist before they went to court for the first time?
Do you have the documents? Okay. It was dismissed on July 29th, 1998,
So about 1 week later, correct?
according to the documents. That's correct.
You have the rule nisi there?
Yeah, I do.
Okay. Rule nisi is just a Latin term that lawyers use to say, come to court, right? Show cause, come to court,
Okay.
right?
I don't speak Latin, but I'm assuming if you're saying that, that's correct.
I appreciate your confidence in me. So they go to court and the TPO is dismissed, correct?
That is correct.
And that doesn't happen without a judge sitting on the bench, correct?
Correct. And usually when it's dismissed, one of the parties are not showing up. Just like when in the court case, when the party doesn't show up, it's dismissed.
But every party's here for this. For the TPO dismissal, everybody's in court.
Okay.
In fact, were you aware from talking to people that the judge encouraged them to talk to each other? They talked to each other, and then the judge dismissed the TPO.
I'm not surprised in court hearings.
I didn't ask if you were surprised. I asked, are you aware that that's what happened?
I'm not aware.
Well, did you ever interview anybody about what happened in that court proceeding?
It's pertaining to the TPO?
Yes.
No, sir. The TPO is not related. It's not part of my murder investigation. It documents of first form of interaction that documents the domestic violence between Christopher Wolfenbarger and Melissa. As far as a homicide investigation, it's not relevant going to the homicide. So there was no reason for you to follow up for it pertaining to this domestic.
Well, are you saying that all the domestic things involved in July 1998 has nothing to do with the investigation of the homicide?
The July 1998 incident is very critical, and it documents and it landmarks a tumultuous relationship between Christopher and Melissa. So it is very important.
You just said it's not relevant. I'm confused between your last two answers. You said you didn't follow up anything about the background of it, anything about what happened in court, anything about any of that, because it's not relevant to the homicide, but then you say it's the landmark most important thing.
That is correct. So when you document an incident domestic, it's documented. It's a homicide investigation. We continue with our homicide investigation. We have reliability when we refer to the police reports, which is official documents. That's documented in time. There's no need me to follow up on the domestic side because we have it clearly documented in the police reports. My investigation continues from the homicide on.
Okay. You don't disagree, though, that even the documents show that the judge approved the dismissal of the TPO. The judge signs it.
And these are legal documents, and I definitely approve of it.
Okay. You then talked about having interviewed Mr. Wolfenbarger in, the first time was in 2021, so now we're 23 years later after the TPO. 23 years after the TPO, you interview him on May 5th, and I think we listened to that tape, correct?
Correct.
2021?
Correct.
Okay, so we don't have anything else at this point between then and 2021, right?
As far as that pertains to what?
Your direct contact.
No, that's the first time I came in contact with Chris.
Okay.
That's correct.
And you meet with him, and you talked to him, and you said it was a voluntary meeting, correct?
Yes, it was in his home, in his living room.
Right. So there was no coercion, no handcuffs. You didn't threaten him, but he voluntarily welcomed you in, gave you a seat at the table, sat down, and talked with you.
Correct.
Totally
custodial.
Totally voluntary.
Correct.
Totally cooperative.
Correct.
Okay. And when you were done with that interview, you packed up your tape recorder and you left, correct?
Correct.
Okay. And then you're continuing to review Calhoun's reports during this time, correct?
Correct.
Okay. In that tape that we heard this morning, Mr. Wolfenbarger told you about a rocky relationship that he had. In part, he attributes it, or perhaps in large part, he attributes it to Melissa Wolfenbarger's parents, correct?
I don't know if he attributed the rockiness to the parents, but he did admit to having a rocky relationship. I don't know how he would attribute it to his parents. As
Not
far
his
as
parents.
rocky relationship. Her parents. Correct.
Her parents.
Correct.
You don't think he was attributing it to that?
No, I'm pretty sure he was not attributing to that. I did not interpret that as his parents being, or her parents being a reason why they have a rocky relationship. That's solely between those two.
But clearly he didn't get along with her parents.
He stated that. That's correct.
Okay. Well, I mean, that wouldn't come as a surprise, would it?
I'm not surprised if anybody's in a tumultuous, rocky, violent relationship. I haven't seen a couple that's had a good relationship with any parents involved in that.
Well, but you know that's not what I'm talking about here. Here I'm talking about the fact that his in-laws had murdered 5 people. Do you have in-laws? Are you married? Can you imagine your wife's parents killed 5 people, threw them in a river?
Hang on.
To the form of the question, improper, Judge, I would ask that the jury be instructed to disregard the form of the question.
I'll withdraw it. But it doesn't. Can I withdraw it?
You can withdraw it.
Does it shock you that someone would say they have a rocky relationship with their in-laws, given what you know are the facts of this case?
I've been doing this job almost a quarter century. I talk to murderers and deal with murders on a daily basis. People from murderers' families. That has nothing to do with what they have to do in their relationship. People can't help who they're related to. Their relationship was their relationship, had nothing to do with their parents.
Okay. So you don't find it surprising that he had a difficult time relating to the family, to the parents who had committed 5 murders, thrown them in a river. There was a baby who died in their home and convicted of concealing the death. None of those things.
None of that came out in the form of evidence during the course of this trial. The counsels have interjected things that are not in evidence and asking questions based on things that aren't in fact. I'd ask that the court instruct counsel not to do that.
Mr. Samuel?
I don't think that's accurate.
I think I've heard the 2 things that you specifically referred to. I've heard testimony about them in this trial, so I'm going to overrule your objection. Go ahead.
But your position is, it's like Tolstoy said, every unhappy family is unhappy in their own way, right?
So
it's just another unhappy family.
So because Melissa was from this type of family, that gave her permission to be victim of a domestic violence? I don't think so.
That rhetorical question doesn't answer my question.
Again, because she was a victim of her family and their wrongdoings does not give Christopher or anybody a right to place her in an abusive relationship. So
I'm going to ask you to stop the answer because my question had nothing to do with whether Mr. Wolfenbarger had the right to do anything. And he denies doing anything. So your answer to that, you can give a closing argument if you want, tell the lawyers to go home. Otherwise, I'd ask you to answer my questions.
Can you repeat your question, sir?
Yes. His in-laws were serial killers, right? And were throwing family members they were killing, throwing their bodies in the river. Melissa's sister had a baby who died at birth and was thrown in the hamper. And your only answer to me is that doesn't give Chris a right to do something?
Absolutely. Christopher does not have a right to abuse Melissa based off of her family history. That is correct.
What makes you think that he was using that as a right?
I'm just basing this off your argument that you're making right now, sir.
I've never said he had a right to do anything. And as I just said, he denies doing anything.
Are you asking me a question?
When was the next time you interviewed Chris?
I have it documented in my reports.
When's the next time you interviewed him?
Can we refer to my reports, the exact date?
You have your reports up there?
No, sir. These are the exhibits that you left.
Okay. Did you interview him again in February of 2023?
Is that documented in my report?
It's documented in my notes.
As soon as I can confirm it's documented in my report, then.
Yeah, those reports.
Yes.
Do you know exactly what page this documentation is going to be in my reports?
Detective Shepard, you testified this morning about the different interviews you have. You didn't require counsel to give you page numbers.
Well, if we were going to refer to dates, then I would like that the notes that you took from my case file, if you can give me the exact date so I can refer to it.
I just told you the date was February 2023.
Okay, on my page in my notes, can you give me the page?
Forget it.
Okay.
We'll move to a different topic. Are you familiar with the circumstances of Melissa and Chris Wolfenbarger moving to Atlanta?
No, I'm not familiar with that.
Do you know when they moved to Atlanta?
No, sir, I do not.
Do you know where they lived when they moved to Atlanta?
They stayed off of Brookline.
Okay. Do you know who owned that property?
I believe Christopher's mother owned that property.
Okay. And had they been to Atlanta before or in the Atlanta area before that?
I'm not sure.
And did Melissa end up having a series of jobs working at Waffle House when she was in Atlanta?
Correct.
And had friends, correct?
Correct.
Okay. And you know that from talking to some of the friends, correct? And talking to people at the Waffle House, correct?
Correct. And also, Christopher's statement was that she worked at the Waffle House and had friends at the Waffle House.
Right. And she wasn't isolated in Atlanta, was she?
I'm not going to say isolated, but there was some, according to the reports that documented that they didn't always see her, but they always saw Christopher. She was always
Who's the they in that sentence?
some of the witnesses that was interviewed and that's documented in the case file.
Didn't Miss Cooley talk about how they would play all the time? She'd see Chris all the time?
I'm sorry, you say Miss Cooley?
Mm-hmm.
I'm not familiar with a Miss Cooley.
Okay. Did you read Calhoun's reports?
I did.
Did you read them before you came into court here?
Yes, sir, but I'm not familiar with a Miss Cooley.
Okay. How many times did you talk to the folks at the glass company?
In person, I was able to interview them one time.
Okay. And did you determine from talking to Mr. Brock that ultimately Chris was let go because of a car accident involving one of the company's trucks?
Yes, also the saw that he borrowed.
Is that a yes or a no?
Yes, he also borrowed a saw that he never returned.
He borrowed a saw that he never returned.
Those were their words, correct, that he never returned the saw.
Okay. Those weren't your words this morning. Are you aware of that?
Correct. The Mr. Brooks, they said that
Brock.
Mr. Brock, thank you, that he borrowed the saw along with some type of violation that he did with the vehicle. They couldn't prove that he stole the saw, but they let him go as a result.
Okay. You talked about talking with Thomas Dixon, right?
That is correct.
Okay. He'd spent, 10 years in prison between the time of 99, 2000 and the time you met with him, right?
Yes, he was in and out of prison. At that time, he was currently getting his life together. So that is correct.
And then you talked about the time of Chris's arrest, right?
Correct. Yes.
And you said that he was not cooperative at the time of his arrest, correct?
That is correct. He hid in the cupboard that he built inside of his home, and it took, I believe, fugitive about 30 minutes or plus to find him.
Yeah. He had met with Calhoun how many times? Voluntarily meeting with Calhoun.
It's more than one time.
How many times did he meet with Detective Stott, who was here this morning? Voluntarily, either went to his police department or met with him and was fully cooperative with him.
I have no direct knowledge of Detective Stott or his interactions with Christopher.
Okay. You haven't read his reports?
I have no direct knowledge of Detective Stott or his interactions with Christopher.
Okay, but my question was, have you read his reports?
No, and I don't have any firsthand knowledge of his interactions with Christopher.
Okay. What about Calhoun's reports?
Correct. Yes, I have.
And Mr. Wolfenbarger's cooperation with him?
Yes, yes. Spoke with him multiple times. There is one time that he met with Detective Calhoun, and Detective Calhoun advised that he stole a search warrant that he had. He had to go back and get it from Christopher. That was one interaction that he had with Christopher. So I wouldn't categorize or describe his whole interactions as cooperative.
Okay. At the time of his arrest, how many law enforcement officers went to his house?
You have to refer to the fugitive report, and they should have a list of every law enforcement officer that was assisted in that arrest.
Do you know how many people went to the house?
Offhand, I do not know, but usually when you're trying to apprehend a fugitive for murder, there's going to be a great number of law enforcement.
So if Detective O'Hare was in here yesterday or 2 days ago and said there were 30 officers who went to the house, you wouldn't question that, would you?
That sounds about right. And it's always a tactical safe play or a way to apprehend a fugitive that's wanted for murder.
Said most of them were armed with assault weapons.
That sounds about right, correct.
And helmets and gear and flak jackets and all of that, correct?
That is correct.
Yeah. And used a battering ram to get into the... Well, I'm going to ask you, did they use a battering ram to get in?
I have no direct knowledge on how they made entry into the house. From what I do believe, I do understand that his wife, or at the time what was described as wife, answered the door and she lied and said he wasn't there. And then they was able to make entry and find him. I don't have any knowledge of a ram being used.
Okay. But that is inconsistent with all the cooperation he showed you and Calhoun and Stott over the course of 20 years of answering all your questions, meeting with you, coming to your office, correct?
Incorrect. Whenever you're trying to apprehend a fugitive wanted for a violent crime, which is murder, then you're going to go in the most tactical force used, and that's to ensure the safety on both sides of law enforcement and the civilians that we're trying to obtain.
Yeah, I wasn't meaning to say that the officers were doing anything wrong. I was going to say, if he was uncooperative at that time, it was inconsistent with all the cooperation he had shown you and Stott and Calhoun and Kelly, and, anybody else who he'd been interviewed by with over the years.
So based on the way you framed your question, inconsistent meaning that he hid in the cupboard, and he did not hide when we went to go talk to him, but he did hide when they arrived for his arrest. That's correct. He did hide when that arrest happened, and he did speak with us in person.
Yeah, and he had voluntarily given pubic hair to Calhoun.
Correct.
He had voluntarily given other hair samples at other times he was requested, correct?
Correct, and also...
My question was just a yes or no. He also gave DNA evidence when requested, correct? Buccal swabs.
That is correct.
He also, there was the luminol was used in his house, correct?
Correct. 3 years after the incident, though, and the house had been remodeled.
So all those were done in a cooperative manner. Some you had to get a search warrant for, but others he did in a cooperative manner. So
the last incident that you're referring to is the luminol. A search warrant had to be obtained. So I don't know, I don't have any direct knowledge of interaction at that time that Christopher had with the detectives performing that search warrant.
Well, he wasn't even living there when the luminol was given out.
Okay, so that answers the question. He didn't.
And also, during the course of the questioning by Mr. Fawcett here, you repeatedly talked about things that you found important, correct?
Correct.
Okay. Did you find it important that the pubic hair that he gave to the officers and that was tested was not shown to be consistent with what was found in the bags?
All DNA is important, but also I had to keep in mind that this case was older. Also, I got to keep in mind that the condition of the body parts that were found, and also over time, those things fade. So we're going to do it just to check the boxes and make sure we're going to cross our T's and dot our I's. But also in the back of my mind, I do know that the DNA was going to be compromised because it was compromised.
But the pubic hair was analyzed and was found to be not consistent with what was found in the bag.
So the way I remember the report saying it was dissimilar, and also pubic hairs and hairs degrade over time, and that's the way the report read. By the time this particular item was tested, years had passed it. So over time, DNA does degrade, and pubic hairs and DNA items such as that will degrade.
And you know from the other officer who was with you earlier today and sitting outside that he had done DNA from what was found on the bag, and all of that came back negative.
Are you referring to Detective Stein?
Yeah.
Yeah, so Detective Stein and myself, we did work on this case earlier, and he was definitely a big part of collecting that DNA for further testing.
And it came back as not being consistent with Mr. Wolfenbarger's DNA.
That's correct.
Okay. And you know about the paint chips that were found inside the bag that didn't match anything in the house.
That's correct, but also at the time when they did serve the search warrant at the house had been remodeled. That particular area had been remodeled, so it was not going to be uncommon that those paint chips were going to be dissimilar to one another.
Right. So do I gather that all the evidence that exonerates him, that shows that he's not the person who perpetrated the crime, you consider to be insignificant?
That's incorrect. If you're referring to just physical evidence in that manner, no, but you still have other evidence that goes in line and testimonies that go in line with this case.
I'm just asking about the physical evidence. You downplay the significance of all of that, don't you?
Can never downplay physical evidence. Physical evidence is important, but what you have to keep in mind that over time, physical evidence degrades. And this case is a prime example of that.
You know that cadaver dogs were sent out to the house, correct?
I heard of an incident. I don't have any direct knowledge of cadaver dogs or APD using any cadaver dogs.
Okay. There's no evidence of, first of all, there was no saw found in the house or in the house where he was arrested years later, correct?
No, the only reference to a saw is when Christopher admitted that he was in possession of, or he was accused of being in possession of while he was let go from his job.
Right. There's no evidence where the dismemberment occurred.
Absolutely. There's no evidence where it could have occurred anywhere.
When you were questioning Chris in the 2021 that we listened to, you asked him to say who he thought had killed his wife, correct?
I believe we asked him what did he think happened.
Right. And he responded, of course, he initially said the family, correct? Her family, her parents.
Correct. He wanted.
And then he said, he then said, but listen, I'm just speculating, correct?
Well, we have to go in order. To answer the question, he pointed all the blame to the father and the family. And what he's referring to when he's saying speculating, he's speculating on different parts of the interview and different parts of the statement that he made.
Yeah. One second, Your Honor.
Sure.
Detective Shepard, you were testifying as to the collection of DNA and the degradation of DNA over time. You recall that?
Yes, sir.
All right. Now, did you have an opportunity to view the conditions of that the remains of Melissa Wolfenbarger were located in?
Yes, I did.
And photographs and the actual scene itself?
Yes, I did.
And did you receive any indication in your reports of any weather conditions that would have existed during around the time that her remains were discovered?
Yes, it was a heavy downpour, a lot of rain in the area.
And is there, in your investigation, have you worked cases where you've been able to successfully collect the presence of DNA?
It's a crap shot. Sometimes I may not. In this particular case, when the particular items that we're referring to that get the DNA when it's compromised, like her body parts was in, like you might as well say, like a soup in those bags, definitely know they're going to be compromised.
You say like a soup. What do you mean by that?
So when it's in a plastic bag, there's a lot of rain. It was in a junkyard. It's a lot of areas, so it's a lot of other things that can come into contact with her remains of compromise, along with a natural weather event like rain. And
we're talking about the time period of April through June. Is that a period of time you would consider to be a particularly hot or particularly cold period of time?
That's a time of the year that when the seasons are changing, we usually get a lot of rain. In Georgia and Atlanta, that's the time when the weather started changing, the trees started blooming. So yes, we're going to get a lot of rain during that time.
All right, and also heat, does that have an impact on the ability to collect DNA samples?
It does, but that's not going to stop us from trying to collect them.
All right. Now, you testified as to information you received specifically as it relates to any FBI determinations as to the quality or degradation of hair that you would have that would have been in connection with this case. Do you recall when those reports would have been created?
Yes, I have it documented in the report. I believe her name was Dr. Cornsberry.
Okay. And did you have a copy of Dr. Cornsberg's report in your in Discovery?
Yes.
Do you recall that date offhand?
Not offhand, no, I do not.
If you were to review a copy of her report, would that refresh your recollection as to that report?
Yes, it will.
You can review that to yourself.
Yes.
All right. After having reviewed that, is your recollection refreshes to the date of the report?
Sorry. Yes, the date of the report is October 30th, 2007.
And is that when the police department received information about the quality of samples that you were going to either make a decision about further testing?
Correct.
And based on the information about the quality of the hair sample, was it either Calhoun's decision or your decision to send off for additional testing based off of the information that you received?
Detective Calhoun's.
Okay. But ultimately, when you reviewed the case, you decided your decision was the same as Calhoun. Is that safe to say?
Correct.
And in connection with your interview of the defendant in 2021, had you previously either spoken to Detective Calhoun and or viewed any statements that the defendant made with Calhoun?
Yes.
And were those statements important for comparing and contrasting any similarities and differences between those two statements?
Yes.
And if you found, I guess, things that you viewed as being dissimilar, would that have been significant in your investigation?
Yes.
In particular, questions related to when the last time would have been that Christopher Wolfenbarger would have observed Melissa alive. Specifically that question. You recall asking the defendant that question in 21?
Yes. It gave conflicting answers. One answer was that he dropped her off and she just walked away. The next time he said that they went to Taco Bell and then he dropped her at a train station.
Okay. And I want to refer you to a previously admitted exhibit. I believe it's 73. Okay. Your Honor, with the court's permission, this exhibit 73, which has been tendered into evidence, I'd ask the court's permission to play portions 24-20 through 29.
Can you tell me what 73 is?
It is the interview with Detective Scott.
Connected to DHCP L540039F10.
Hang on just one second. Can you come here?
that you've heard back from the grapevine or before then? As far as like, a week before you saw her or something like that? I know the guy that used to live right next door to me. He used to work for Marta. He kept trying to go down to downtown. And right around that time, he had told me that he had seen her. He got off at 5 Point Station downtown, and he got off and she kept going straight. I heard him tell me that. Over here somewhere when he called before. Said back before when she was up at the Waffle House in Florida that she was involved with some guy named Mike. Remember that story? Was Mike an employee over there? Yeah. You know if they were living together or seeing each other? That's what I was told. That's what she told me. And they had a friend, I can't remember the other friend that I talked to. Because their friend actually called me, when we were going to take her back from up there out of that situation. They said at one point that she was possibly staying at the shower lodge. Yeah, that's where her friend lived at. They tried to call her. I went up there and I picked her up from there one night. But she apparently, I don't know if she was in love with this guy or what too much about it. Did you know his last name was? I didn't know the first thing I said, I can't remember. White guy. That sounds right, yeah. I remember he had curly hair. See, now I'm trying to be rude, but I got to go back to real bad. I go pee.
Now, we've concluded the tape.
2856.
2856. All right. Now, Detective Shepard, do you recall in your interview with the defendant, we've just listened to a portion of the interview with Detective Stott and Detective Calhoun. Did you get an opportunity to listen to that as the jury was playing it?
Yes,
was
sir,
the jury
I
was
did.
listening? Okay.
I did.
And do you recall in the interview that we just listened to, did you hear the portion of the interview when the defendant indicates last time being March or April that he saw Melissa Wolfenbarger?
Yes.
And that was the next year, which appears it would have been 1999. You recall that?
Yes.
And is that also the same time period where Melissa's remains were discovered?
Yes.
And is there anything different about the time period, March or April of 1999, where the defendant indicates he saw Melissa Wolfenbarger, and the time when he told you in 2021?
The exact date, do you have a report that I can refer to? The exact date did he?
I believe you have your reports up there with you.
Yeah, so it was May 5th, 2021, when me and Sergeant Layton interviewed Christopher.
Okay. All right. Do you recall the defendant indicating that the last time he saw Miss Melissa Wolfenbarger would have been in December of '98?
Yes.
You recall that?
Yes.
Did that distinction between the December 1998 date that the defendant gave you and the March '99 date that the defendant gave Calhoun, was that something you factored into your investigation?
Yes, it was definitely a red flag.
Is that something you considered inconsistent?
Correct.
Your testimony, you were just testifying as to the cooperation of this defendant. You referenced an obstruction of a search warrant. Is that correct?
Correct. Regarding to Detective Calhoun?
Yes.
Yes.
And do you recall what the nature of what law enforcement or Detective Calhoun was attempting to retrieve with that search warrant?
Some DNA.
Okay. And your testimony is that there was an obstruction charge related to destroying that search warrant. Is that correct?
Yes, he stole a search warrant and then destroyed it.
You also testified as to the level of cooperation when you arrived at the defendant's residence when law enforcement arrived to effect the arrest warrant. I believe you testified that the female was dishonest about his whereabouts when law enforcement arrived. Is that also correct?
That is correct.
And did you ultimately find the defendant at the residence where that female was dishonest?
Yes, they found him in a makeshift hole in the wall that he had behind an appliance.
And you were also testifying as to the protective order and the request for dismissal. Did it come up in your investigation that on that July 29th date, Melissa Wolfenbarger's children went back with the defendant's mother, Kathy Wolfenbarger?
Yes, and around that same time frame, correct.
Did you factor in, during your course of investigation, did you also know that Kathy Wolfenbarger had custody of Melissa Wolfenbarger's children?
Yes.
And did that factor into any consideration you had as to Melissa's ability to leave the relationship?
It did, and it factored in a great deal.
What do you mean by that?
So it's pretty odd that a mother would give up her children, but it also makes it really hard in the domestic situation, a violent, tumultuous domestic situation, for them to leave when the person that's responsible for that domestic abuse parent is in charge of your children.
Okay. That's all I have, Judge.
Thank you, Mr. Seymour.
Yeah. Something when you just began the redirect examination here about the weather when the skull was found.
Correct.
What was the weather that you think it was?
There are reports of the weather inside the case file. During that time frame when she went missing, in that time frame, the first body part was discovered, which is her head. There was rain.
How did you just describe that rain to Mr. Fawcett?
Well, there was a downpour multiple times during that time period.
Okay, can I show you Mr. Calhoun's report?
Sure. Intermittent mist.
Intermittent mist?
Overcast, correct.
Intermittent mist is the same as a downpour?
So as we know, when it rains, it's not constantly raining as a downpour constantly, unless it's some type of hurricane or something like that in the area. I don't recall a hurricane or anything like that type of weather event at the time that report was made, so it's not unusual for it to be misting at that time, especially after a rain.
But you weren't there. You're just going by Calhoun's reports, right?
Correct.
So you're answering Mr. Fawcett's question saying it was a downpour, but all you have is Calhoun's report that said it was misting.
Correct. As homicide detectives, that's why reports are very important. They document the incident. That's all we have to go on. Like a police report is a legal document, and we refer to those documents.
Can I approach?
Yes.
You
don't have to ask again.
The National Climate Center reports about rainfall.
Okay.
How much rain was there in April of that year?
I'm not a meteorologist, and I don't feel comfortable interpreting this weather report.
Your Honor, I'd like to tender this as evidence.
Mr. Fawcett,
No objection.
what is going to be the exhibit designation?
What number are we up to?
10.
D10. D10 is admitted.
Thank you. The right-hand column is the total rainfall for the month. month, what was the total rainfall in April?
Can you point to the... Okay, the item that you have circled,
Is the total?
that's what you're saying? Okay, the item that you have,
No,
For that day.
for that day, sorry.
okay, item that you have circled is 0.27. What type of measurement is this, though? Is this in inches, millimeters? That's why I don't feel comfortable trying to interpret this.
I guess what I'm trying to ask is, what made you tell ADA Fawcett that it was a downpour, when in fact you have no evidence to support that, the scientific evidence doesn't support it, and Calhoun's report doesn't support it?
Based off the documentation from the reports and interviewing and talking to Detective Calhoun, that's the information that I gathered.
Well, we just showed you the report. It said it was misting. It didn't say anything about a downpour.
The report is missed, and that's what Detective Calhoun documented in his report, with actually being present on the scene. For those 3 months, there's not a documentation of that. So in those 3 months, I don't think there was a drought during those 3 months, so it definitely rained. But he documented a misting on the crime scene.
So if we bring Calhoun back, he's going to reaffirm that he told you that it downpours that month?
If you bring Detective Calhoun back, I can't speak on what he's going to say. We can only go off the reports and things that are documented.
The difference in time between these inconsistent statements by Mr. Wolfenbarger about the last time he saw Melissa was how many years?
Which incident are you referring to?
What you just answered, Mr. Fawcett, on redirect.
Can you be specific, please?
There were 2 different interviews he gave. You said it was significant that they were inconsistent about the last time he saw Ms. Wolfenbarger.
Okay, so the first interview was when Detective Calhoun came in contact with the case in 2003. I interviewed Christopher in 2021.
So over the course of 18 years, the first time he said it was the end of 99, correct? The end of 98. And when he talked to you, he said it's the other way around. When he talked the first time, he said it was March or April of 98, and with you, he said let me start over. He said it was March or April of 99 when he talked to the first officer, and he said it was the end of 98 when he talked to you, correct?
Correct, but truth is going to be consistent. It doesn't matter how much time passed. If you're telling the truth, that's going to be consistent.
Okay.
So when we hear inconsistencies, that's a red flag. Only lies come inconsistent. Truth stays consistent no matter when it's told.
Okay. Even with an 18-year memory lapse between the two.
Absolutely.
You remember where you were 18 years ago?
I do.
On this date 18 years ago?
Not on this specific day, but on this specific year and this month, I do. I can't tell you exactly where I was.
Okay. All right. And were the same questions asked of him about location on those 2 different events? 2 different times? The first time when it was Stott who was interviewing him, correct?
I'm not sure.
Okay. And did he say what street he remembered last seeing her?
Can we?
He was asked about the last time you saw him on.
Are you referring to the
Street?
statement that he made to Detective Stott?
Yes.
All right, can we replay it? I'm not familiar with the
I'm not
interview
gonna
with
replay it.
Detective Stott.
Do you know today, sitting here, whether the 2 statements asked him the last time he saw her at the same location as opposed to at different locations?
I have no direct knowledge to Detective Stott. I haven't spoken with Detective Stott. The detective that was primary had this case before me is Detective Calhoun.
Okay, but just a minute ago, for ADF Fawcett, you said the 2 inconsistencies were dramatically important to you.
Yes, every inconsistency is important, especially during a homicide investigation.
But if the 2 questions are different, then they're not inconsistent, right?
That's incorrect. You can ask a question in many different ways, and the truth is going to stay the same. We find consistency. That's what we do as detectives, as homicide detectives. We talk to all type of people that lies all the time. There's one thing that's going to be consistent is the truth. So we look for consistency. When there's inconsistency, there's lies.
So if the first time he's asked, when's the last time you saw her, on Lee Street, and the second time, when's the last time you saw her on a different street? If it's different times, you'd say that's an inconsistency.
I would say if it's a truth, it will be consistent.
Nothing further.
Thank you. Mr. Fausett, anything else for this witness?
No, Your Honor.
Okay, thank you, sir. You may step down. You're
Yes, ma'am.
excused.
Thank you.
Have a good day.
You too.
State may call its next witness.
Your Honor, we asked to call Dr. Hoppel, but I think we need to have her patch into the Zoom.
Has she already done so? No, we have to let her in, but has she already attempted?
Okay, I think we had told her to stay. All right, so.
Well, she wouldn't be able to because we won't let her in, but that's okay. Ladies and gentlemen, we have some technical stuff we have to take care of for just a minute, so I'm going to excuse you to just grab a quick cup of coffee or whatever, just hopefully for about 5 minutes or so, and we'll get you back in here as quick as we can. The jury's clear. I apologize. I didn't realize that she was the immediate next witness. I would have been more clear to tell you to tell her to go ahead and log into the Zoom because she would have just stayed in the waiting room until my staff let her in. But now we know.
Mr. Wolfenbarger,
Yes,
say
absolutely.
step out, but I
Yeah,
think you
if
know
he
what I
needs to
mean.
take a comfort.